what that doctrine states and where the limits are?
Yes, Your Honor.
You understand that you cannot terminate an employee for reasons covered under Civil Rights Act of '64?
I do, Your Honor.
You understand you can't terminate an employee for any of the statutes under Sarbanes-Oxley, Fair Labor Standards Act, and other replicable pertinent laws?
I do, Your Honor.
You realize that McGarity has claimed that you are in fact in violation of the law against the whistleblower statute?
I am, Your Honor.
And you are aware that Indiana Supreme Court found in favor of McGarity?
After they found in favor of us.
And so we understand the law. Then tell me, on what ethical basis do you want us to find for summary judgment in your favor? On what ethical basis?
That they are at-will employees, and we employed them for as long as they did what we needed them to do.
I'm still not sure I understand the ethical basis of it.
It's not ethically wrong for us to terminate somebody for not performing their duty.
Okay, all right. Let's hear from counsel for McGarity. They said that it's not unethical for them to terminate you for whatever reason they want to terminate you for.
Your Honor, I would like to start with my opening.
And we can't do that yet.
Okay.
Let's just get this motion out of the way.
Your Honor, it is not.
You want to step up?
It is not ethically or morally correct for an employee to be fired for any reason other than just cause. My client was not fired for a just cause. He was fired in retaliation for not committing illegal acts.
Okay. Were those illegal acts also immoral acts?
They were immoral acts. And my client was performing his job. He was competent, he was skilled, and they sought him out based on his competency.
Counsel, step back up. Did you fire the employee based on immoral reasons?
No, Your Honor.
If you did, would you still be asking for summary judgment?
No, Your Honor.
Okay. Both counselors approach. Good try, counsel, but we ain't going for it. But we appreciate that you made a concise argument.
Thank you, Your Honor.
Motion for summary judgment dismissed. We're going to open an argument, and for that, counselor, since you're already on the roll, it's good. Why don't we stick with you?
Good day, Your Honor.
Good day.
Okay. We are. I have a question. My question is, what are Berlin Metal's moral responsibilities to McGarity? Do we have a moral responsibility to McGarity? We offered Mr. McGarity compensation to perform certain tasks, and he was terminated because he didn't want to perform those tasks. We, as Berlin Metal, do not think it's morally wrong to terminate somebody for not performing tasks that we paid them for. Mr. McGarity had a choice. We all have choices. His choice was, if I don't agree with Berlin Metal's policies, then I can go have employment somewhere else. I may think it's morally wrong to kill people. Well then, I don't need to join the military. I don't need to take a job as an executioner in a prison because as part of my job, sometime I'm going to have to kill somebody. So if McGarity doesn't believe it's morally right to perform the task that we asked them to do, then they don't need to be employed by Berlin Metal. And we are going to prove today that we compensated Berlin Metals for the tasks that they performed, and when they refused to do what we asked them to, they were terminated. Thank you, Your Honor.
Great. Appreciate your insight, Counselor.
Good afternoon, Your Honors. Your Honors, we're here in the Court of Morality today to present facts about two wrongs leveled against my client. First, my client, John P. McGarity, was fired for failing to comply with BMI's scheme to defraud the state of Indiana. BMI fired him simply out of retaliation. Secondly, it was morally wrong for BMI to breach their contract with my client that would have provided him with employment until his retirement. According to the Indiana Code, it is a Class D felony, and it's morally wrong for any person to make and subscribe to false information on any kind of tax return. Attempting to execute a scheme, any kind of a scheme, to defraud a state, a federal, or any kind of federal institution is a Class C felony. It's morally wrong, and my client refused to have any kind of involvement. Deliberately under-reporting corporate tax liability is illegal. It's morally wrong, and it goes against public policy. Defrauding the state and its lenders by misclassifying the location of inventory. It's illegal, and it's morally wrong. Mr. McGarrity's status as a loyal agent of BMI did not require him to commit a crime as a condition of his employment. It just did not. And he had no ethical responsibility to certify the monthly financial statements of BMI. According to Velasquez, who is one of the most probably popular ethic researchers that we have today, a loyal agent to a corporation does not imply that an agent has a duty to perform acts which are illegal or unethical. BMI limited my client in performing his duties. When a company limits employees from performing morally loyal agency is then affected. It did not matter that BMI claimed that they did not ask my client directly to commit an illegal act. My client knew it was wrong. Because he knew it was wrong, this is a professional accountant, a CFO. He knew it was morally wrong. If my client would have certified the false financial and tax statements and the tax records, he would have been morally responsible because he knew it was wrong. BMI's negative rights do not take precedence over my client's positive rights. BMI does have a right to make a profit, but not at the expense of my client. If it is morally wrong for an employer to do something out of self-interest, it is then morally wrong to do it on behalf of that company. And regarding the breach of contract to provide Mr. McGarrity with employment until his retirement, let me make it clear to the court that BMI sought out my client. BMI sought him out because they were having financial problems. My client left his current position and joined BMI, and he had to relocate his family. BMI's rep did make it clear that employees left their employment of their own accord and that they did not get involved with employees leaving their company. But during the recruiting process, my client stated that he and his family were not interested in leaving their company, leaving his retirement benefits, relocating if they were not assured of job permanency. My client received those assurances from BMI. Because BMI deliberately set out to injure my client financially, BMI is morally responsible for his financial salary losses. I submit to the court of morality that he was fired for retaliatory reasons and not for any just cause. My client was qualified to do the work. And he was sought out because he was qualified, because he was competent. They sought him out. The legal and moral standard is that as long as an employee is performing the duties of the job, then they should only be fired for just cause or good cause. My client has the law and public opinion on his side. There are limits to every employer's powers. Those limits are defined by legal and social institutions. Your Honor, I submit to the court that unreasonable demands were placed on my client to be deceptive and dishonest. That is morally wrong, and it goes against the public's interest. And I'll quote two additional principles from Velazquez. In any situation, the right action is the action that will produce the greatest net benefit to our society. Cheating our society, denying our society tax revenue is not benefiting our society. When BMI was trying to do, what they were trying to do was wrong because of the costly effect, if for nothing else, the costly effects that it would have had on our society. Decreasing state revenues will affect our society, and it has affected my client.
Okay, all right. Both sides were asked to come and prepare to argue 3 points. The first one being around law agency, the second one around moral responsibility, and the third around moral contracts. Counselor, let's hear from Berlin first. Was Mr. McGarity a loyal agent?
Your Honor, Mr. McGarity was a loyal agent. And we say that Mr. McGarity was a loyal agent at one point because he was hired to protect the best interest of the company, its shareholders, and his co-workers. So at the end, he was not a loyal agent because he didn't act loyal. So at the beginning, we had a moral contract for him to be a loyal agent of the company. And we